Do you see slides?
Yep. We're good. Uh,
Okay. This is. Let me pull up my notes on another computer. Okay. Are we live?
Are live with Charles Duan talking about legal citation.
So I have like zero sense of what the audience looks like, and I can also really hear myself, which is kind of strange.
yeah, we can all hear you. You can open the YouTube live stream if you want to see what the audience is like. But we can't give you a direct feed, unfortunately.
Okay. Um, the sound is very much echoing back to me. Is there any way that we can turn that off? Otherwise, I'll just take the headphones off while I'm presenting. Wait, I think it's better.
Should be good now.
Okay. All right. Get started. Thanks so much for your patience, and thanks everybody for helping out with the AV issues. I really apologize for all of this confusion. And also thanks to James and to the organizers of this conference for inviting me to talk about this. So this is a project that I have been working on basically ever since I was in law school, on developing a computer program that did my legal citations. And so this is something that I've been using for a long time. And as I've been working on it, I think that the insight that I've developed is that legal citations are actually more complicated than I expect, and that's not just because the Blue Book makes it so. And so what I want to do is share a little bit of those insights with you today by thinking about legal citations as the title suggests, as a programming language. Now, we all know that legal citation is extremely weird. This is just a random page from the famous case, as in the rule in Shelley's case, from Sir Edward Cook's reports, and you can see the
Sorry,
citations there.
child.
It's
Really,
just a bunch of numbers.
sorry, Charles. Really quick.
Yeah,
For us, we only see the first slide right now.
you
Are you?
still see the first slide.
Yeah.
Okay, do you see slides moving around?
No, I think we might have seen your mouse, but
No. Okay, let me try doing it not full screen. Does this help? Okay, so what do you see now?
we're still on the first slide, but we also see your Discord. Oh, sorry. Give
You're
us
still
one
on
sec.
the
Give us one sec. Okay. Yeah. Now we see slide 2, I think.
Okay, the one that's got like some old text.
Yep.
Okay, now let me ask you this. If I present, do you now see that same slide?
Yes.
Okay, if I move to the next slide, do you see the next slide?
Yep.
Okay, I'll hopefully it's working at this point.
Yeah, I think it looks.
Okay, so all right. So as I was saying, this is a very old version of legal citation from about the 16th century. And number one, you can see it uses a ton of abbreviations. It uses all of this Latin. It seems very obscure. And so you would think that after 400 years, maybe we've gotten a little bit better, but no, we haven't. Here is a contemporary piece. This is actually something that I wrote myself. And you can again see that there's all sorts of fonts, there are a lot of abbreviations. It tends to look very imposing, I think, and before I was a lawyer, I often wondered what is going on with these legal citations. It seemed to be the sort of mysterious code, possibly what people who are programmers look at computer programs like. And so this has obviously been it's the system of legal citation, besides just being sort of weirdly archaic, has been heavily criticized over many years. It's been called overly complex. It's been called arcane. Every once in a while, somebody will write a law review article, basically making fun of the updates to the legal citation system, and primarily the key manual for it, the Blue Book. So there are a number of articles titled "An Uninformed System of Citation," or "The Blue Book Blues," or "The Folly of the Embedded Full Citation," or "Oh no, yet another revision to the Blue Book." Besides this criticism, there's also pretty good evidence that the whole system is just very wasteful. Wasteful of time, wasteful of money, and wasteful of intellect, in a sense. Editors at law schools, so student editors who review journal articles, spend most of their time making sure that the citation formats are correct and arguing over whether commas should be going before or after the quotation marks. Paralegals charge hundreds of dollars an hour, basically doing the same thing, making sure that the formatting of citations are correct. There have been plenty of attempts to try to address this problem. Students at the University of Chicago put together an alternative system of citation, the what they called the Maroon Book. The Association of Legal Writing Directors, or ALWOD, created a competing legal citation manual called the ALWOD Manual. And then there are also attempts at automating the whole process. So we have a number of citation managers, Zotero, Jurasm, Mendeley, and EndNote, who all implement various forms of legal citation compatibility, basically things that are like BibTeX for legal citations. All of these exist. Very few of them have really succeeded. The Chicago Manual, the Maroon Book, which Judge Potter praised as this paragon of conciseness at its origin, I think it was only 15 pages long, has now ballooned to over 120 pages of citation manual. The ALWOD Manual, the same thing. And all of the automated citation systems that I mentioned here are generally understood to be a pretty good first cut, but not a perfect solution, and they all say you have to go back and manually edit your citations before you're able to submit. So what's going on here? Why do we have this very complicated system that has so far seemingly defied any sort of automation or systematization or attempts at simplification? I'm going to argue that the fundamental problem, not just inertia, which one we might think of, or not just unusually detailed rules that the Blue Book has, but actually a conceptual problem, that we need to basically better understand what legal citation is. Regular citation systems, like in computer science or in the humanities or other areas, are fundamentally pointers to authority. Cite something to tell somebody this proposition is supported by this reference. And as a result, we have lots and lots of really good systems for doing this. Legal citation, on the other hand, does a lot more than simply point. It, in fact, I'm going to argue, is an entire language and allows for people to be expressive and argumentative purely through the citation system. And as a result, if we're going to try to improve the state of legal citation today, either by automating it, by developing automated automated citation tools, or by trying to improve the system through better manuals, education, or simplification of the system, we have to understand how the system works as a language. We have to see what its purposes are, what affordances it provides in order to achieve those purposes. And from that understanding, we might have a shot at actually building something that really addresses the complexity of legal citation. In a sense, This talk is just a tutorial on the system that I built to do this. This is a program called Here and After. You can access it on GitHub. I've been meaning to put it on Citan. So this is a LaTeX package that I put together over the last couple of years, as I mentioned. And so in a sense, this is just a talk about how the system works. But I think it actually goes a little bit further than that. Because the broader story is that it's an investigation into the grammar and the structure of the legal system as I've discerned it through my work in putting this together. And I hope that some of the lessons that I've learned and some of these broader ideas can help us basically gain a better understanding of legal citation overall beyond this one particular program that I've developed. All right, so let's get into it. First of all, I mentioned that legal citation seems like this language. It seems like much more than simply a way of pointing people to authority. So what are those things that it does? Well, so legal citation certainly does point people to authorities. You use a citation to support propositions, and that's probably the primary purpose of a legal citation. But you can also do a lot of other things. You can highlight a debate among scholars or among courts. You can cite several different cases, for example, in a single citation, and say, hey, this case is on one side and this other case is on another side, and you can explain to people there is a debate going on simply within the citation system. You can use citations to impress your readers. A lot of times when you open up a law review article on the second, third page, the entire thing will be filled with citations. What impression do you get from that? You're looking at that and you're saying, wow, this person must have really researched this subject, or they must be really knowledgeable, or they must really like showing off because they filled their entire page with citations. But in that sense, the citation page is serving a communicative function that goes beyond simply pointing people to authority. You can also use citations to identify the authoritativeness of the things that you're citing. In law, we spend a lot of time thinking not just about what people say, but about who said it. One court is not the same as another court. If the Supreme Court said something, it's different from just like a trial court saying that. And the ability of the citation system to easily convey who the speaker is and the speaker's authority is a pretty important feature of a legal citation system. You can also use citations to show historical development. Often what you can do is you can trace the entire history of a legal doctrine or a line of argument, possibly through centuries, simply by listing the citations with their dates. And in fact, one of the rules that we have in legal citation is that you should present things in a certain chronological order, all other things being equal, in order to show that sort of historical development. Citations often are also used not just to support things with authority, but also to criticize and distinguish authority. You might cite a reference in order to say this reference is problematic, or this reference actually shows that there's a debate, or I disagree with this reference. And there are ways of indicating that disagreement through the citation system itself. You can also use it to celebrate people's scholarship by identifying the names of authors or by identifying articles in ways that tend to promote it. This is kind of the opposite of the criticizing function. So legal citation serves all of these functions. Now, of course, in any sort of literature, you can do all of this. Nothing stops you from highlighting a debate in computer science by simply citing a bunch of works and talking about the debate. What I'm saying here, though, is that you can achieve these functions purely within the citation system itself, simply within a single citation without external text. You can actually do all of these things. And these are the sorts of expressive functions that I find within legal citation that I think make the system very unique, and make it sort of explain why it requires a lot of this complexity. Let me show you Let me show you an example of this. So this is another piece that that I took for my own writing. Here you see we've got so this is in the context of a discussion about some court decisions on how computer programs work and how they function with regard to computers, with regard to computer hardware. And so prior to the quote that I'm reading here, I quoted another part of a case. And what I'm going to do now is I'm going to disagree with what the court says. And so I have some text that explains my points of disagreement. But then I'm going to use the citations, the legal citation system to highlight exactly how I disagree and how I believe that disagreement has played out. So you'll start out by seeing that CF thing, right? That's what we call a signal. That introduces the citation and tells you what I'm using the citation for. Ordinarily, if I just said nothing, or if I said C, if my signal was C, that would be like, okay, if you want support for this proposition that I've given you, see this reference. CF, compare in Latin, means that thing that I just said, compare it to this thing. And that means I'm going to tell you something kind of interesting about the citation that might make you think further about what was just said. So the signal there indicates that I'm about to have a conversation with you that goes beyond simply what the citation is all about. We then have the name of the case. We have an identifier. So the case is named Alapad. We have an identifier, that 33 F third at 1566. You can treat that basically as a document identifier. That's what allows you to go look up the case. Then we have this parenthetical, parenthesis Archer C.J. dissenting. That's what we call a parenthetical. We attach those to the ends of citations in order to give more information about the thing being cited. And here we learn a couple of very interesting things about the thing I'm citing. Number one, we learn that the person who's speaking in the part that I want to reference is the chief judge of a court, who's named Archer. So the CJ tells you about the weight of authority. It tells you that this person's a chief judge, probably a pretty important person. It also tells you that this person is dissenting from the rest of the opinion. So at this point now we have a pretty good sense of what the authority of the thing being said is. We can then follow a second parenthetical that provides a quote from the original source, and that provides basically argumentation as to why I'm using the reference. And so that just kind of adds to the value of the citation as not just a pointer to authority, but as a point of argumentation. We then have a semicolon, a second citation, and another parenthetical that again gives some more information about basically my points of disagreement with the case. So you can see that this citation is not simply pointing people to authority, it is pointing people to authority. It is pointing the reader to, if you want to see my reasons for disagreement, here are all of the people who have agreed with my point of disagreement. But it's also saying, this is the weight of authority that it carries. These are the types of people who are saying it, and here is exactly where I think they have made the arguments that you should be looking at. And in general, here are a couple of the features of legal citations that I think get us to the point of legal citation serving all of these expressive and communicative purposes. So number one, signals, I just talked about those. Those are the things that say, this is why I'm citing something. You put that in front of the citation. Those parentheticals that I just mentioned, they can give more information. They can give further argument through quotes or through description. Embedded citations are a very interesting feature of legal citation that I don't think I've seen anywhere else. You can cite something and then inside a parenthetical cite something else, basically saying here's an authority that quotes another authority and cite the thing that's being quoted. Basically, you do that to further enhance the believability of the thing that you're citing, because it's like, not only do I have this great authority to support the thing I'm saying, but they were quoting from another great authority. So you can use sort of embedding of citations and multiple layers of citations to further strengthen an argument. Similarly, you can use references that connect. You can say, here is a thing that I want to cite, and it was quoted in all of these other things. And that just, again, is useful to enhance the weight of authority of something that you're citing. You could say, not only am I quoting this, but here are a bunch of other really famous people who quoted it. You should really believe this. A couple of other interesting sort of affordances that I identify in legal citation, the way that we talk about authors. In general, for most disciplines, authors are authors, and we just say, you identify the authors by name. In law, though, we care a lot about the institutions that authors are affiliated with. And as a result, legal citation systems provide fairly complex rules for attaching institution names to human authors. And one of the problems actually is that the ways in which these are structured have been kind of underspecified. And so one of the problems that I've had to deal with developing my software is figuring out what sort of the grammar of specifying authors when you have both human authors and institutional authors. That's been a problem that I've had to spend some time thinking about. And finally, there's a fairly complex grammar of page numbers and dates, because of the fact that those are important features of legal citations. You have to know when something was said. You have to know exactly where on the page something was said, because a lot of these law review articles run run like 100 pages long. And as a result, all of these sorts of things have to be specified within a legal citation system in order for the citation system really to serve all of the communicative functions that lawyers hope to take advantage of and that law scholars hope to take advantage of. So that's kind of the first sort of like major premise of developing a legal citation system that I think is important. The idea that there are many purposes that the citation system serves, and as a result, we have to think about a lot of different affordances that the system should provide us, such as the ones I've just listed. Here's the second big premise. In the legal citation system, we have people who write and we have people who read. Now, this is, of course, true about any sort of citation system, but I think it's particularly pertinent for law because we spend a lot of time thinking about writers and about different types of readers, because we have lots of different audiences that we're speaking to in law. We have judges, we have law scholars, we have practitioners and such. And the things that they need out of legal citation are different between readers and writers. What they're looking for are fast visual cues and clear conventions that provide all of that information that I just talked about. Be able to tell that something is from a court versus from a law journal versus from a statute very quickly, because that helps you assess whether or not something carries a lot of authority as you're reading. And that's why we spend a lot of time using like small caps in legal citations. That's why we use all of these parentheticals, because they provide those fast visual cues for identifying what an authority is, who the speaker is, what its purpose is within a piece of writing. At the same time, if we were to fully describe every single thing that is being cited, law review articles would get only longer, because a lot of those titles of articles are very long. And as a result, we take advantage of a lot of abbreviations. Readers want abbreviations because they make sure that there isn't that the page doesn't get too full. Abbreviations, though, require a piece of writing to be stateful. As you read through the article, the first time you present a citation, you give a full citation. You provide all the bibliographic information. The second, third, fourth time, you'll use a shortened form. Sometimes we'll just use an id or an ibid in order to save as much space as possible. Again, this is basically for convenience of readers, so that they don't have to see the same large string of text multiple times in a row. Writers, on the other hand, as they're writing documents, I think are looking for something somewhat different. Number one, they want things to be easy to write. Every time I want to write a citation, I don't want to spend a lot of time going back to the manual looking up whether or not I'm supposed to use small caps or italics in a place. I want to just be able to type things quickly. I also want flexibility in the order of my work as I'm writing. If I decide that I'm really on a roll typing, I just want to be able to type. I don't want to have to stop and go and look up a source and find all the bibliographic information. Maybe I want to be able to save that for later, right? That's one of the things that I always really liked about systems like BibTeX. You could just put in citation commands into a document. Without actually filling in what the citation is for, you would compile it, you get an error, but then you can go back and you can fill that in later. So you can adjust your workflow. So you don't have to adjust your workflow based on the citation system. The citation system can work with your workflow. The third thing, and I think the most important thing that I would want as a writer in a citation system, is statelessness. as I'm editing, I might decide that, you know, I've written section 1 and I've written section 2. I think that section 2 is in the wrong place. It should go before section 1. So I just want to be able to copy section 2 right above section 1. If I'm working with a document that is full of stateful citations, that has lots of id and supra and lots of cross-references, when I copy those citations over from one place to another, everything is broken. You end up with something that looks like this. This is not real, but this is what a lot of my articles used to look like. You end up with these blanks and fill in things and reminders and question marks. And the reason that people write like this, including myself, is that in a system where in a system of citation that's designed for readers, where we do a full citation first and then we go down and down using short citations. If I want to be able to edit the document, I need to come up with essentially my own sorts of conventions for how I want to write. And those end up being essentially ad hoc and idiosyncratic to the writer. So what I'm hoping to do, So what I'm hoping to do with my program, with my citation program, is essentially develop a language for writers of legal citations. Basically, come up with a convenient way of writing out citations during the writing process that an automated computer program can then translate into the proper formatted legal citations that are more convenient for readers. This is just like what any of the other sort of automated legal citation, or what any of the other non-legal citation systems do. It have to adapt it to this much more complex grammar and set of affordances that legal citations provides us. So let's talk about what that grammar looks like. Let's look at what legal citation looks like when we try to break it down as if it were a sort of programming language, as if it had a grammatical structure. The first thing we do is we break them down in the same way that other citation systems do. We have citations and we have references. So anybody who's worked with a citation management system will be familiar with this. The references are the individual works that you're citing. You enter them, you give them nicknames, and you provide bibliographic information for them through sort of like a key value format. And that defines all of the things that you can cite, all of the documents that you might want to cite throughout your document. In Hereinafter, there is a little bit more complexity to the references, mostly because you end up with some situations with legal documents where you can have a document inside another document, and there are certain special ways in which I need to deal with that. But generally, references are defined in a way that's very similar to how how any other citation management system would do it, by providing metadata for individual documents. It's really the citations, the places in your document where you refer to the references so that information about the references is inserted, where a lot of the magic happens. Because we have to add in ways of talking about the parentheticals, the signals, the page numbers, and all of the other sorts of information that I mentioned are included in legal citations. We could do this, but we could do this by just having a bunch of commands that do each of those. But one of the things that I found is that ends up just becoming so verbose that it becomes almost too time consuming to actually write out citations, particularly if you want to write out a fairly long citation. And so what I instead have developed is a domain specific language for specifying the content of a legal citation. There are two components to that domain-specific language. The first is that there are several different types of legal citations. Broadly speaking, you can cite something in text as part of a sentence, or you can cite something separate from the text as its own independent sentence or clause, set apart from the rest of the text. And so I provide, so all of this is in tech. So I provide a number of commands that that allow you to do both of those. The commands inline and adjective, those allow for making citations that fall within a sentence. The difference between inline and adjective is that every once in a while you have a reference that starts with the word the. And so if you use it in an adjective context, you want to take the word the out. And then I also provide two commands for non-sentence, non-inline citations. Those are the sentence and clause commands. And so the example here, you can see both of those at work. You first see inline bracket Brown was decided in 1954. So that's going to put the name of the case, Brown versus Board of Education, as if it were a noun within the sentence. So you see that that generates Brown versus Board of Education was decided in 1954. That's followed in the code by \sentence C Brown. And so that translates through the program into a citation that follows the sentence. You see the italicized C, that's the signal again, and then 347 US 483, that's the document identifier, and a parenthetical for the year. One thing you might notice is that in the citation in the sentence form citation, the name of the case, Brown versus Board of Education, has been automatically omitted because that tends to be the convention in legal writing, that if you've already identified a case name, it's omitted from the. If you've already identified a case name in text in an inline form, you omit it from the citation form. And so one of the nice things about doing this by computer program is that that can be done automatically. Okay, so these are your two sort of broad categories of ways of using citations within a document. The thing between the braces is a specification of what you want to cite. And now we can talk about the grammar of that. So within those braces, you put a thing called a citation string. And a citation string is one or more citations that are separated by semicolons. And so the idea is that this is supposed to be a series of things that you want to cite. A citation then is composed of a number of elements. First of all, it has a signal. And so I've given a couple of examples of signals here. So e.g., see also. You prepend that at the beginning of your text with a citation string. You can then optionally provide a volume number to the extent that your reference is multi-volume. This is mostly useful for books. You then provide the reference name, so that would be the nickname of the reference that you want to cite, and then you provide information about the page number. Actually, that's a mistake. That should be the at page should be optional, because you can omit the page number if you'd like, and then finally you follow that with a number of parentheticals. Parentheticals are worth about just a little bit more in detail, because there are a couple of different ways in which parentheticals show up in legal citations. One of them, of course, is just parentheses and a bunch of text, and you can, of course, do that. That's the second alternative given in the grammar here. But the first alternative is where you want to refer to another work that's related. If your work is quoting another work or is quoted in another work. What you can do here is in here and after is you can provide the relationship, that's the related grammatical element. Those are typically going to be words that end with, quoted in, or cited in, or discussed in, or ing verbs such as quoting, or discussing, or contradicting, or something like that. And then you provide another citation string within the parenthetical, and that automatically creates an embedded citation, or basically a number of citations in sequence. And so again, that allows you to have that conversation among references, where you're saying, here is one reference, and that reference was quoted in this other reference, and maybe it was followed up by this other reference, and you can tell an entire story just through using this sort of parenthetical form of multiple citations. So here are a couple of examples of how that works. So here I've got got a definition of a case. This is Wheaton versus Peters. And so you can see, like other bibliographic reference systems, we've got a couple of pieces of metadata that define the elements of this Wheaton versus Peters case, and its identifier, the party names. And then you have sentence, brace, Wheaton at 602-603. That Wheaton at 602-603, that's the specification for the citation that follows that domain-specific language that I just talked about. And then hereinafter, we'll automatically compile that and convert that to the formatted citation that's below. This is just talking. So one thing that I provide is a slightly simplified way of entering references, because often you type in cases, it gets a little tedious to type in all of the parameters for cases. And I can talk a little more about sort of the entry of references, if that's of interest to anybody. Here's a more complicated example, and I hope that this shows kind of some of the key features of the citation system. So number one, you can see within this sentence, the citation string contains a number of different elements. Those are separated by semicolons. You can see citations to cases. You can see parentheticals like the stating case parenthetical or proposing theory parenthetical. You can see signals, the word C that's used in a number of the citations that allows you to insert that. And then you can also see this parenthetical citing : Wheaton at 688. That, again, is this embedded citation idea that allows you to say how one reference talks about another reference. And as you can see, all of that is automatically converted into appropriate formatting for legal citations in the examples below. Now, I mentioned that the really important thing about the system is statelessness, is the idea that you can move parts of text around without having to worry about your citations going all awry. And here's an example of how that works. So what I did here is I took, in the previous example, you see I had two sentence commands, one of which was much longer and the other which was shorter. Here I've switched them around. They're otherwise the same, and I didn't change anything string in the stuff between the braces. I just copy and pasted them. But you can see that the citations that are generated are fairly different at this point. You see id citations, and you see a short citation to the Banks case in the second longer string of citations, whereas in the previous example, it had to use a full citation to that because that was the first time we talked about the Banks case. And so this is really sort of the power of the system, that it allows you to easily move things around without having to deal with the problem of rewriting your citations. And yet it also captures, at least I hope, much of the flexibility and the power of the expressive functions of the legal citation system. And I think that that combination of these two things really has made this a very powerful system, at least for me. And I think has been really instrumental to my legal writing over the years. What are some things that I think are potential future work that come out of this thing? So number one, statutes. Statutes are very complicated as documents. I'm not totally sure how to think about them. Second of all, there are lots of forms, there are lots of types of documents for which I don't have predefined citation formats, and it's fairly hard to define new ones. And I think a big part of the project will be thinking about ways of making sure that there are people other than me who can expand the system. Compatibility with other systems is something I've been thinking about. I would like to easily be able to take a Blue Book formatted article and convert that to Chicago format or to Oscola format or to some other legal system. I would also like it to be easily convertible to BibTeX or to some other systems. I have ways of doing that right now, but they feel rudimentary and somewhat hackish, and I think that there are ways of improving that. The holy grail is Word compatibility, Microsoft Word compatibility, because like it or not, most legal scholars use Microsoft Word and most legal practitioners use Microsoft Word. I think there are a lot of difficulties with this just because that legal citation is so expressive. It doesn't really comport with Word's internal model of citation. But I think that that would be a really interesting problem to think about. And finally, I've been talking about this in terms of a computer system, but I also think that this provides new avenues for thinking about how to teach legal citation. Because rather than just teaching legal citation as a bunch of weird rules about formatting and small caps, this is about teaching the system as a means of expression. And I feel like that's just a very different way of thinking about what the purpose of legal citation is. That really would be informative. Even from somebody's very early stages in the legal profession. So I think that there are a lot of things potentially to be done and to be thought about here. This is just sort of my initial forays into this problem, and would love to hear your thoughts about this. Thanks, everybody.